All right. So the United States Constitution, Article 3. Article 3 covers the judicial power of the United States. And it starts with the judicial power of the United States shall be invested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So when I use the Brown text, that's a direct quote from the Constitution. The judicial vesting clause, as this clause I just read is called, grants the courts the power to neutrally interpret the law and to apply it to the facts of a case and to render a judgment. So the courts will look at the law that relates to a particular case and look at the facts in that case and apply the law to those facts. So they'll see how the law applies in this particular case, and then they render a judgment based on that. And a second power that they have is to review the constitutionality of laws. And this comes from the case of Marbury versus Madison in 1803, that the Supreme Court says they have the power, the right to determine whether a law is constitutional or not, whether it's in keeping with the restrictions of the Constitution or if it exceeds those restrictions. As the Declaration of Independence states, he, the king, has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. So in this article, the founders are establishing the judicial power and allowing Congress to set up the rules for how this is carried out. So they want to make sure that the administration of justice is carried out. So they're establishing judicial powers here. It also grants lifetime appointment and no reduction in pay to the judges. And this is to ensure that they're independent, because one of the complaints in the Declaration was that the king has made judges dependent on his will alone for the tenure of their offices and the amount of and payment of their salaries. So the king was very much the boss of the judges in colonial times. If he didn't like them, he could fire them, he could cut their pay. So if he's their boss, basically they're going to listen to him and do what he says. So that doesn't make for a very independent judiciary. So the founders wanted to make sure that the judges were independent so that their tenure, their term of office was for their lifetime until they retire or decide to resign. And but no one can kick them out, and also their pay can't be cut. So that gives them independence from the other branches. As they were deliberating in the Constitutional Convention about the courts, the framers believed that republican liberty, and we live in a republic, which means we're under the rule of law, not a democracy. We're not ruled only by majority vote. We're republic, which is living under a law, the Constitution, and the laws that follow from that. And that to secure the liberty from the rule of law, we required an independent judiciary. So different from England, they wanted to separate the judiciary. In England, it was part of the executive. It was under the king. Although they acknowledged it was a separate function from the executive, it was still together administratively. So that the king still had power over the judges. So they wanted to separate the judiciary from the executive function. And some argued that state courts would be sufficient for deciding issues, but others, such as James Madison, won the argument that there should be a national judicial power. So hence they set up a federal court system in Article 3 of the Constitution. However, the details of the courts were left largely up to Congress, entirely for the inferior courts and mostly for the Supreme Court as well. So this is kind of a contrast from Articles 1 and 2, where there's a very specific listing of powers. Articles 1 lists a lot of powers for Congress, and Article 2 lists various powers of the president. But Article 3 doesn't have a list of powers as Articles 1 and 2 do. So it's kind of a difference in that case. So the size of the Supreme Court is set by Congress, not the Constitution. There's no number of justices in the Constitution for the Supreme Court. So Congress can set up the number of judges. Congress first set up the Supreme Court with the Judiciary Act of 1789. So the Constitution was written in 1787 and approved by 1788. So in 1789, when Congress started meeting, they set up a Judiciary Act to establish the courts. So they established 6 justices on the Supreme Court and several district courts and 3 circuit courts. Each circuit court had 2 riding Supreme Court justices. So the Supreme Court justices would ride their horses around to different towns in the circuit and hold court. So that the court could be present closer to the people where it was needed. Of course, now we don't have a riding Supreme Court justice. They only serve in Washington. They also had appellate jurisdiction over federal issues from state court litigation. So if a trial rises through the state courts, it can be appealed to the Supreme Court if it deals with a federal issue. And they also confined the Supreme Court to questions of law rather than fact, which was unusual to limit appellate courts at that time in that way. But they wanted to do that so it couldn't overturn a local jury findings. So if a jury had decided someone was innocent, then the Supreme Court couldn't go in and say, well, the jury was wrong there. Actually, this person's guilty. They could say the law wasn't interpreted correctly, but they couldn't change the result of the jury. So between 1801 and 1869, the size varied briefly. For a year, it was 5, and up to 9 and even 10 during Civil War, due to the politics of the North and South and struggles with trying to gain an upper hand. But since 1869, it's remained at 9. In 1937, Franklin Roosevelt tried to increase it to as much as 15 because he was upset that the Supreme Court was declaring too many of his New Deal programs unconstitutional. So he didn't like that and wanted to put more people friendly to him on the court. But that was soundly voted down, even by his own party. His own party said that's too much of a power grab. However, this week, the Democrats have introduced a bill to raise it to 13. So we see that the size has varied somewhat over the years, but for the last 150 plus years, it's remained at 9. But now the Democrats would raise it to 13, which would surprisingly give them a majority in the Supreme Court. So they're also trying to grab power, and we should resist that, because if the Congress just increases the size of the court to be whatever is enough to make their side victorious in cases, then we don't have an independent judiciary, we just have another political branch. So the point of the judiciary is to independently and neutrally interpret the laws. So the cases that the court hears, they take cases which are justiciable, which is a strange word, but anyway, it means presented in a form that's suitable for judicial resolution. Something that a court can say, this is constitutional or unconstitutional, or this person is guilty or not, things along those lines. So they've kind of established over time a number of screens for what cases they would take. So first of all, they say court decisions are final and cannot be re-examined by Congress or the president. And also that judges will not render legal advice to political officials outside of a contested case. George Washington had even asked them for an opinion on a treaty he was considering, but they said, no, we're not giving legal advice outside of cases. So only if a case comes before the court will they decide on it. So those two have remained pretty constant throughout the course of our history. that court decisions are final and judges don't render legal advice outside of the case. However, the next few have waxed and waned in their application. So courts will not decide political questions, which are matters which are constitutionally given to the Congress or the president. This one, sometimes they don't decide political questions. Other times they certainly do. Such as in 1973, they decided Roe versus Wade. They said that abortion is legal, and that's very much a political question. Congress could make a law for or against abortion, but the court got into the issue and decided to decide a political question. So in that case, they weren't following the screen of not deciding political questions, but they very much did. Another case maybe is in 2015 when they declared that homosexual marriage was allowed. So they certainly have gotten into political questions at various times. Sometimes they decide, no, this is too political, we won't do it, we won't want it. Also, the plaintiff, the one bringing the case, must have standing, which means that they have to show that actual harm was done to that individual by the adverse defendant. The most recent case of this was when, in the recent election, when President Trump brought a case saying there was fraud and that affected my reelection. They said he didn't have standing. Now, it seemed to me that actual harm was done to him by their unwillingness to rule on this. But anyway, they used this as a reason for why they wouldn't hear the case. Another screen they use is the claim must be ripe. Sounds a little strange, but basically it's sufficiently developed both factually and legally. They don't want to jump in too early. They want things to, the laws and the facts to be known before they jump into a case. And also that it's not a moot point. So if the dispute between the parties is ended, why would they bother to rule on which one was right and which one was wrong if they're no longer fighting about it or it doesn't matter anymore? So over time, they apply more or less of these constraints as to what cases they'll hear. But the first two have remained constant throughout our history. Section 2 covers the scope of their power. So it starts out, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. So this gives the federal courts a broad jurisdiction over cases arising under the Constitution and laws. And as I was reading this, I said, okay, all cases in law and equity. Well, what does that mean? So after some digging, I learned that in law means a remedy following from the law, which is derived from common law. Common law is developed by tradition over time in England. So it dates back to the time of William the Conqueror and the Normans invading England in 1066, and the king starting to send his judges around, and they would see what their traditions were in different locations in England. And they kind of pick the best of those and start applying those throughout the land. So in time, the law was commonly applied across the country. So it became known as common law. And a lot of it wasn't written down. It was just traditions that developed over time. So we have taken this English system of common law and imported it largely into our judicial system in America. Common law was somewhat limited in the remedies it could have, such as it could only have monetary compensation as a remedy for a case. So over time, sometimes people felt that the judgment from a common law court wasn't fair, so they started appealing to the king. And they would appeal to the king, and the king kind of delegated this to the Lord Chancellor. So over time, the chancery courts run by the Lord Chancellor became a parallel system of courts which developed in England to remedy aspects of common law which were seen as unfair. So these were known as equity cases. So equity remedies include things like injunction, like telling a person to stop doing something or to do something. The court issues an injunction saying that they must do or stop doing something. Also performance of a contract or returning to a previous situation. So these are things that are not monetary compensation, but are results that hopefully give a more fair result from the law. So England had these parallel systems of law courts, common law courts, and equity courts. In America, we've combined those into one court system. So both courts, our courts can apply both law and equity rulings in America. So the cases, the types of cases the courts can take um, include all cases affecting ambassadors, other public ministers and councils, all cases of admiralty and maritime jurisdiction, controversies to which the United States is a party, the United States government, controversies between two or more states. So if two states have a conflict between them, a boundary dispute or something else, they can come to the court to have that settled. Between a state and the citizens of another state or citizens of different states. If you're citizens of the same state, presumably you'll take your case to state court and have it heard there. But if you're from different states, then you can come to the federal courts. Also between citizens of the same state claiming lands under grants of different states. So when you have differences between the states, either the states themselves or citizens in the states, it can come to the federal courts. And it says also between a state or citizens thereof and foreign states, citizens or subjects. So this is a pretty comprehensive list of anything that isn't just citizens within the same state, which would be heard in state courts. So section 2 continues on original and appellate jurisdiction. It says, in all cases affecting ambassadors, other public ministers and consuls, those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So original jurisdiction means the case can start there, start in this case in the Supreme Court. So this is a very limited scope. There's not that many cases between states and ambassadors and public ministers. So the Supreme Court hears very few original jurisdiction cases. The most recent one I'm aware of that came before the Supreme Court was again from the recent election when the state of Texas was suing the state of Pennsylvania and some others, I believe, saying that because they didn't follow the Constitution, saying that only the state legislatures can set election law, that Texas's vote was harmed because Pennsylvania was not following the Constitution. So they took that directly to the Supreme Court because that's an issue between two states. So the Supreme Court would have original jurisdiction. The case can start in the Supreme Court. However, in that case, the court refused to hear it. And it continues, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. So appellate jurisdiction is a court of appeals. So the Supreme Court can review appeals from lower courts. So we have district courts, appellate courts, and then the Supreme Court. And so if a party in a case thinks the lower court has made a mistake, they can appeal their case to have that mistake rectified. So if a lower court decided that the law applies in this manner and a party says, no, I think they didn't apply the law correctly, then they can appeal first to the appellate courts and then to the Supreme Court. And the Supreme Court can rule whether the law was properly applied in that case. So section 2 continues on trial by jury. It says the trial of all crimes, except in cases of impeachment, shall be by jury. Such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as Congress may by law have directed. So again, Congress can set up laws dealing with things like crimes not committed in a state, maybe at sea or somewhere else. So it says trials shall be jury trials in the state where the crime was committed. So according to English common law, one's guilt or innocence was to be determined by a trial of your peers. In other words, ordinary citizens. No judge or court official determines your guilt unless you waive your right to a jury trial. So a judge only determines the sentence after a jury has returned a guilty verdict. So this is a major difference between English common law and continental European systems. In continental laws, French, etc., the judge determines both your guilt and what your sentence is. But this was another separation of powers that the founders incorporated into our Constitution, saying, even though the judicial system judges cases, the actual decision of guilt or innocence is left to ordinary citizens, a jury, not the judge. So that takes an important power away from judges and gives it to citizens. So even though, I too think it's a pain when I get a jury summons saying, oh, you have to serve on a jury. Actually, this is a very important protection of our liberties in the Constitution, and that just ordinary citizens, other people just like you, will will hear the case and decide guilt or innocence. And this is reaffirmed in the Seventh Amendment. Also, the trial is held close to where the person lives, so it's not an excessive burden to attend it. From the Declaration of Independence, one of the complaints against the king was for transporting us beyond seas to be tried for pretended offenses. So the king would take colonists sometimes to England beyond the seas from America to be tried. So that was an undue burden that the founders objected to. Also, trial by jury was one of the few issues on which the Federalists were for the Constitution and the Anti-Federalists against it. Both agreed. The Declaration that again says about the king for depriving us in many cases of the benefits of trial by jury. Jefferson even said if he has a choice between the people being involved in the legislative process and the judicial process, he'd prefer them to be, if he could only pick one, he'd prefer them to be involved in the judicial process. He thought trial by jury was that important. Section 3 talks about treason. So it says treason against the United States shall consist only of levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on the confession in open court. So this is a narrowly defined definition of treason, and it has a high bar for proof so that the government wouldn't abuse it and use it against their political enemies. So it's only levying war against them or giving aid and comfort to enemies. So it can't just be thinking about it or not liking somebody, or you actually have to engage in war against them. And also that you have to have the testimony of at least two witnesses to the same act, which is a biblically derived principle from Deuteronomy 19:15, which says, one witness is not enough to convict anyone accused of any crime or offense that they may have committed. The matter must be established by the testimony of two or three witnesses. So we see that the founders incorporated biblical wisdom into the Constitution as they were writing it. The punishment for treason says, the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Okay, so what does all that mean? So once a person was determined guilty of treason, they were attaint or tainted, which means they were considered dead in the eyes of the law because the penalty was death. So even before they were actually executed, the law saw them as being dead because the penalty was death. So even before that execution, they were considered tainted or stained. So therefore, they said the attainted person, if they were technically dead, forfeited their property and their titles up to the crown in England. Thus, no one could inherit from such a person. So this was the corruption of blood. So if someone had a title and they were technically dead, that title went to the crown instead of going to their their sons or daughters, um, and their property as well would be taken by the king instead of going to their relatives. So this punished innocent relatives, and thus the Constitution prohibited it. So the corruption of blood or forfeiture was prohibited in the Constitution. So only the one guilty of treason and not their innocent relatives would be punished. And Congress can also be more lenient in punishment than the death penalty. Traditionally, death was the penalty for treason. But Congress can make have the power to declare what the punishment is. So oftentimes the punishment is much less than death. Probably the most famous death penalty for treason was the case of Ernest and Julia Rosenberg. The Rosenbergs were stealing nuclear secrets and giving them to the Soviet Union in the 1950s. And they were accused of treason and sentenced to death for that. But many times the punishment is more lenient and doesn't lead to the death penalty. So in conclusion, the courts are there to interpret the law. They're an independent branch of the government, separate from creating the laws, the legislative, and enforcing the laws, executive branches. The founders specifically didn't have the courts have any review over laws as they're passed. That was an idea that some people had come up with, but they wanted it to be separate from making and enforcing the laws. And as a check on the other branches, they can declare laws and executive actions unconstitutional, but only as cases are brought to the courts. They can't just look over and say, oh, that law you just passed, I don't like it, I declare it unconstitutional. They have to wait until a case is brought before them before they can rule on it. The president appoints and the Senate approves judges, so the executive and legislative branches influence who's in the judiciary branch, but to maintain their independence, they have lifetime appointments and a guaranteed salary. So that covers Article 3.